On May 17, 2025, someone allegedly forged a signature on a resignation letter for a political party's vice chairman. That forged piece of paper has now frozen the entire opposition party for over 6 months. 6 months while the trial judge, Justice Emeka Nwite, sat on his hands. 6 months of watching a party die in slow motion, while 4 powerful people, whose jobs are to deliver justice, did absolutely nothing to stop it. Between April 1st and April 5th, 2026, just 4 days, over 500,000 Nigerians joined the African Democratic Congress, 500,000 people. They joined a party that cannot hold meetings, cannot elect leaders, cannot prepare for elections. They joined as an act of defiance. And what is happening is this: 4 people, an INEC chairman, a trial judge, a chief justice, and an attorney general, are strangling opposition politics. Not with guns, with court orders and procedural delays and silence. The big question is, do we want a country where a flimsy, easy-to-resolve case can upend democracy and enthrone dictatorship? On May 17, 2025, somewhere in Nigeria, a document was signed. It purports to be the resignation letter of Nafu Bala, the national vice chairman of the African Democratic Congress. It bears his name, it bears what looks like his signature. But here is the thing: Nafu Bala will later stand in front of a camera and swear that he never wrote it. "That is not my signature," he said. "It was forged." That single document, real or fake, becomes the fuse for one of the most consequential political crises in Nigeria's recent history. To enable change of leadership, on July 2nd, 2025, the ADC National Working Committee, led by Raf Nwosu, resigned en masse. Then on July 29th, 2025, the NEC meeting at the Chelsea Hotel in Abuja. INEC officials were present. The meeting concluded with a major announcement. Former Senate President David Mark was appointed interim national chairman, and former Osun State Governor Ralph Arebasola emerges as national secretary. INEC subsequently uploaded their names onto its official website. From the outside, this looks like a done deal. INEC monitored the meeting, INEC recognized the outcome, case closed. But Nafu Bala has a different interpretation. September 2nd, 2025, Bala filed a suit at the Federal High Court in Abuja. His argument is simple and compelling. By the ADC's constitution, when the national chairman resigns, the national vice chairman assumes leadership in an acting capacity. He did not resign. The May 17th letter is a forgery. Therefore, he is the legitimate acting national chairman of ADC. The case was assigned to Honorable Justice Emeka Nwite, a Federal High Court judge in Abuja. He will now become the single most important judicial actor in this drama. On September 12, 2025, INEC filed its response, and here is where things get interesting. The Commission asked the court not to interfere in what it describes as the internal affair of the ADC. Bala's request, INEC argues, is essentially asking the court to dabble into a political question which remains the exclusive preserve of political parties. Think about that. INEC is standing before a judge saying, "Your Honor, the court should stay out of this. Political parties should manage their own affair." That is a principled position. It is also, as we shall see, a position that INEC will later completely abandon. Later on December 2025, Bala's legal team filed a motion to restrain the Mark faction from parading as party leaders. The motion sits before Justice Nwite, and again, for 6 months, Justice Nwite did nothing. No judgment for the two cases. From September 2025 to March 2026, the ADC was in limbo. Justice Nwite did not deliver substantive judgment. The David Marks faction continues to operate as the recognized leadership. INEC still has their names on its portal. The Bala faction insists that nothing should change until the judge speaks. In the life of a political party, preparing for an election cycle, 6 months is an eternity. Congress cannot be held, candidates cannot be screened, momentum cannot be built. The ADC is frozen, and the man with the key is Justice Emeka Nwite. But on March 12, 2026, the Court of Appeal finally intervened. The Mark faction had filed an interlocutory appeal challenging jurisdiction of Emeka Nwite and probably to hasten legal process. The appellate court dismisses it as incompetent and unmeritorious. But here is the crucial part. The court knows that Justice Nwite has not actually issued any substantive ruling. So, it orders all parties to maintain the status quo ante bellum, the state of affairs before the crisis began. Pending determination of the case. Do not change anything, freeze everything. This order becomes the legal foundation for everything that follows. Now, let me introduce you to the 4 people who will interpret, implement, and weaponize the Court of Appeals order. The first person is Professor Josh Ojo Amopeton, SAN, Professor of Law, Senior Advocate of Nigeria, appointed by President Bola Ahmed Tinubu as INEC Chairman. He now holds the power to recognize or de-recognize any political party. The second person is Honorable Justice Emeka Nwite. By September 2025, he is presiding over the ADC case. By March 2026, 6 months after the case was filed, he has still not delivered a substantive ruling. The Court of Appeal has told everyone to maintain the status quo. But what is the status quo? Is it before May 2025 or after the July NOEC meeting or after INEC recognized the Mark faction? Justice Nwite does not clarify. His silence becomes a void. His silence becomes a dangerous weapon fashioned against democracy. The third person is Chief Lateef Ola Fabemi, SAN. As the Chief Law Officer of the Federation, Fabemi has the authority to issue legal opinion that bind government agencies. He could clarify the scope of the Court of Appeals order. He could affirm that the right of freedom of association includes the right of political parties to manage their internal affairs. He could speak. He did not. The fourth person is Justice Kudrat Kekere-Kun, appointed by President Tinubu as the 23rd Chief Justice of Nigeria, only the second woman to hold that position. As the head of the judiciary, she has the power to issue practice directions. She can tell every court that pre-election matters must be resolved within specific time frame. She can ensure that no political party remains frozen for months while a judge deliberates. She does not act. 4 people, 1 frozen party, 500,000 new members who cannot participate in any meaningful political activity. Now, unexpectedly, and against its earlier position, on April 1st, 2026, INEC made its move. Citing the Court of Appeals March 12th order, the Commission announced that it will no longer recognize either faction of the ADC. It will not attend their meetings, congresses, or conventions. It will not engage with them at all, pending Justice Nwite's final ruling. The reaction was immediate and fierce. The Mark faction accused INEC of misinterpreting the court order. They demand that Amopeton resigns. Bala's faction sees the decision as vindication. But here is the problem. INEC's neutrality is not neutral. By refusing to engage with any faction, the Commission has effectively paralyzed the entire party. No Congress, no primaries, no candidate nominations. The ADC cannot function. And the 2027 general election are approaching. Amopito went on Arise television to defend his decision. He argues that if David Mark's faction goes ahead with congresses, while Bala's motion is pending, it would amount to fostering a fait accompli on the court. He insists the commission is simply complying with the court order. But critics point to a glaring contradiction. INEC's own affidavit, filed on September 12, 2025, argued that courts should not interfere in internal parties' affair. Now, INEC is using a court order to justify interfering by effectively shutting down the party. The contradiction is glaring and surprising. Between April 1st and April 5th, 2026, over 500,000 Nigerians joined ADC. 500,000 people in 4 days. They are joining a party that cannot hold meetings, cannot elect leaders, cannot prepare for elections. They are joining as an act of defiance. They are joining because they see what is happening and they do not like it. I'm not here to just describe a problem. This situation can be fixed. Here is how. First remedy. Justice Emeka Nwite must deliver a substantive ruling within 30 days. 6 months is too long for a party leadership dispute to linger. The Court of Appeal has already spoken. A ruling would end the vacuum. INEC would know who to recognize. The party could resume functioning. Second remedy is Chief Justice Kudrat Kekerekun must issue a practice direction. She has the authority to establish that all political party leadership disputes must be resolved within 90 days of filing. This is not radical. Many countries have similar rules. Her silence has been deafening. She can break that silence tomorrow. Third remedy, INEC Chairman Josh Amopoto must issue a clarification. His commission's withdrawal of recognition does not need to mean total paralysis. He can clarify that internal party activities, ward meetings, state congresses, candidate screenings can continue without INEC's formal endorsement. It costs nothing. It would signal that INEC facilitates democracy rather than freezing it. For remedy, Attorney General Lateef Fagbemi must issue a public legal opinion. He should affirm that the right to freedom of association under Section 40 of the 1999 Constitution includes the right of individual parties to manage their internal affairs without regulatory interference. This would provide binding guidance to both INEC and the Judiciary. The ADC crisis is a test of whether Nigerian democratic institutions can withstand the pressure of incumbency, a test of whether our courts will prioritize democratic urgency over procedural delay, a test of whether our Electoral Commission sees itself as a facilitator of competition or a goalkeeper for the ruling party, a test of whether our Attorney General will speak up when the rule of law is at risk, a test of whether Chief Justice will use authority to ensure that justice is done and done in time, and a test of whether we the Nigerian people are paying attention. Are we still there? The 4 people at the center of this crisis, Amopiton, Nwite, Kekerekun, and Fagbemi, all have the power to act. Justice Nwite could end the paralysis tomorrow with a single judgment. Chief Justice Kekerekun could issue a practice direction next week. INEC Chairman Amopiton could issue a clarifying statement this afternoon. Attorney General Fagbemi could release a legal opinion by the end of the day. The remedies exist. The question is whether they have the will to apply them. If they do not, if ADC remains frozen while the 2027 election approach, then we will have learned that the scope of opposition has shrunk to the point where few legal defensive actions by 4 people can kill a political party without anyone even noticing. This is not a democracy. This is something entirely different. Do not let them get away with it. Pay attention, share this, because the first thing that dies in democracy is not ballot box. It is attention. And attention is the only thing that can save us.